there's motions to dismiss for all the defendants. I've got two sets. I've got the judge and I've got the law enforcement, and Mr. Arthur has the solicitor's office.
I filed a motion for permanent injunction for my immediate release.
Right, so you
I've
have
literally being held, kidnapped, falsely in prison for South Carolina Department of Correction for the last 10 years. And counted without any jurisdictional.
All right, when I talk, you don't.
Sir?
I said, when I talk, you don't. I'm trying to ask you a question.
Oh, I thought they were finished and I was able to say what I had.
So there is a motion for a permanent injunction filed on behalf of Mr. Dizzley. All right, Mr. Dizzley, I'll be happy to hear from you as to your motion for a permanent injunction.
When I filed this permanent injunction, it's actually directed to the Georgetown County Solicitor's Office and the courts on behalf of my illegal incarceration. So I'm asking the courts to issue an order for my immediate release. Okay, and August 11 of 2021, South Carolina Rules of Court amended Rule 3.8 on South Carolina Appellate Court Rules 3.8. Okay, it specifically states that when a prosecutor knows of clear and convincing evidence or information establishing that a defendant in the prosecutor's jurisdiction was convicted and of an offense that the defendant did not commit, the prosecutor shall make reasonable efforts to seek remedy for the conviction. So, therefore, this injunction is directed toward the courts to show that I'm in prison illegally. And also to the reason that it's directed to the Georgetown County Solicitor's Office and Jimmy Richardson, because the law states that he has to remedy this because it was caused by his office.
What are you currently incarcerated for?
For murder.
And that's what you've been in there for 10 years for?
10 years, sir.
And you went
Well, I
to
need legal law jurisdictional authority.
Did you have a jury trial or did you plead guilty?
I had a jury trial, sir. The purpose of this injunction is for my immediate release. I filed under an emergency statute that I be required a hearing within 24 hours of filing this. And I met all of the requirements for filing this to show that my constitutional rights were being violated and that I would suffer irreparable harm if I didn't receive a hearing within 24 hours of filing under the proper statute. Okay, I'm not sure why the clerk of court didn't schedule the hearing the way it was supposed to be scheduled, the way I requested it, which violates my procedural due process rights under the 14th Amendment. So the clerk of court scheduled these hearings pursuant to the defendants in the lawsuit, which my situation of being illegally incarcerated is more important than answering these defendants right now. This is what I came to court for the motion for my permanent injunction. And I would like to litigate that to show my illegal incarceration so that I can be released. I have two reasons which proves that I'm illegally incarcerated. One of them deals with my Fifth Amendment rights under the Double Jeopardy Clause. And the other one deals with my arrest warrant process and the indictment process, which shows that my indictment is null and void. Okay, under both circumstances, a sentence imposed on me in violation of the Fifth Amendment Double Jeopardy Clause holds no legal authority to hold me in prison. No legal nor jurisdictional authority to hold me in prison. In my first, I want to start off with the double jeopardy issue. In my first trial in 2012, the Honorable Judge Baxter, there was exhibits filed that says that this is the charge that the Honorable Judge Baxter gave. It says, in this state, according to the Constitution, the prosecution must prove their case to the standard of proof we call beyond a reasonable doubt, which is, that is, before a finding of guilt may occur, and if the state fails to meet that burden of proof, to meet this high burden, and if it is a high burden, the defendant is entitled to an acquittal. So he's telling the jury that if the state fails to meet their burden of proof, they must acquit me.
What did the jury determine?
What did the jury determine? We don't get to that, sir.
I assume they
Okay.
determined that they met their burden, see how you're incarcerated.
Sir?
I assume that they found that they had met their burden, seeing how you are incarcerated. Or you say that's the original trial?
No, this is the first trial. Now, after only 3 to 4 hours of deliberations, if you come down to number 27, here's the ruling from the judge. He stopped my jury after only 3 to 4 hours of deliberation. And this is what he stated. Now, what you told us is that you can't reach a unanimous decision. And I would say to you, that's not a failure on your part. That's actually a strong message to the prosecution that they are unable to meet their burden of proof to the extent that they can bring back a unanimous verdict. So he just stated in the jury instruction that if the state failed to meet their burden of proof to convict me, then they must acquit me. Then he turns around and stops my jury from deliberating and literally tells the jury that his reasons for stopping them from deliberating and discharging them is a strong message to the prosecution that they are unable to meet their burden of proof to convict me. According to clearly established United States Supreme Court law, Your Honor, and South Carolina law, that ruling was an acquittal.
Everything that he has talked about occurred in 2014 or before. Therefore, anything that was done by any of these solicitors was almost 10 years ago now. To the extent there would be any claim for civil liability against any of them, those claims would have expired a long time ago, certainly before 2020. His lawsuit, in this case, was filed in 2024, long after the expiration of any statute of limitations that would be applicable to these individual defendants, whether it would be the Tort Claims Act statute of 2 years or 3-year statute that would be applicable to any claims brought against them in their individual capacities for any acts of intentional harm against Mr. Dizzley, or any federal claims against these individuals.
So what is your issue, or how do you feel like you can get by the judicial immunity?
Your Honor, I was given notice that I was coming to court today for a permanent injunction. And you haven't allowed me to fully and fairly present my case. And I'm going to ask you, can I finish, please?
What further do you have to present to the court?
I have more issues to prove. I have a manifest necessity issue, and I have issues with my indictment.
Let's go.
And I have other issues in the injunction also. I want to be able to fully and fairly present my case.
You have, as to that, and I have made my ruling on that it was not a double jeopardy issue. This is still not a double jeopardy issue, and so I'm asking that you move on from that, please.
Is it possible that I can show you South Carolina law? State versus Greg?
I've asked you to move on past it, please. If you'd like me to hear any of your other parts of your motion, I'll be happy to hear it.
Manifest necessity.
I say go ahead with that argument, I'll be happy to hear it.
Sir, there was never a manifest necessity for the Honorable Judge Badger to declare a mistrial in my case. Sir, after only 3 to 4 hours of deliberations, without any consideration to the jury or to my Fifth Amendment value right to have my trial completed by a particular tribunal, on the first day of deliberation, the jury only deliberated for 3 hours and 4 minutes. And they asked the judge whether they could hear testimony from my alibi witnesses. He granted that. After that, they said that we can't reach a decision this evening. It was only around 5:26 when he did that. He allowed them to go home early without giving an hour charge or anything. The next day, they came to court. And they started deliberations at 9:42. However, instead of deliberating, they only sent a series of notes to the judge. The record doesn't establish what these notes said. And the first note was received at 10 a.m. and the reply was sent back at 10:21 a.m. Another note was received at 11 a.m. and the jury could not reach a verdict. At 11:25 a.m., the jury entered the courtroom and the judge gave now in charge and sent them back to deliberate. At 12:20 p.m., the jury foreman sent a note indicating that they were still not able to reach a verdict. The judge then spontaneously called them in the courtroom in front of the jury and declared a mistrial on jury after establishing that
1 minute to wrap it up,
the
please.
state failed to meet their burden of
I'm
proof.
gonna give you 1 minute to wrap it up, please.
1 minute, so I can't finish the rest of my.
1 minute to wrap it up, please. I can't give you all day, no, I've got an entire courtroom full of lawyers and motions and judges, I've been as patient as I can, please, I'm giving you the opportunity to wrap it up, please.
Sir, according to my 14th Amendment due process rights.
Well, you got 48 seconds now.
I should have a fair opportunity to fully and fairly exhibit my case.
The law also says I can control the manner in which all motions are proceeded in this case, and I can control my courtroom, so you've now got 30 seconds,
But you're not allowing me to exhibit my case, sir.
wasting your time.
I can't do anything in 45 seconds, sir. I mean, if you're not gonna give me a fair opportunity
Wrap it up.
to exhibit my case,
Just wrap it up then.
sir, so I have the indictment issue.
What's the indictment issue?
It starts out dealing with my Fourth Amendment rights, sir.
Get to it.
My arrest warrant. We have a copy of my arrest warrant?
No, but what's your concern about your arrest warrant? That's got probably nothing to do with me today.
I filed this stuff to the courts, you know. I don't understand why you don't have these things.
Just direct me where you want me to go in your motion.
Do you have the copy, so you have the injunction, right?
Yes.
Okay, look at the second page, it says part 1,
Okay.
okay? The only, Your Honor, according to the law, the only variable that separates kidnapping from a lawful arrest is probable cause. Okay, the law establishes that when an arresting officer goes before a magistrate to obtain an arrest warrant, he has to prepare an affidavit that establishes probable cause. In that affidavit, the affidavit cannot just merely make vague statements like on such day, such and such just did a crime. It has to establish some type of proof of probable cause of that crime. And this is not what happened.
I'm prepared to make my ruling. You can have a seat, please.
You didn't let me finish arguing my case, sir.
I'm ready to make my ruling. Have a seat, please.
How can you make your ruling,
Deputy,
sir, if I didn't finish my case?
All right. As to the outstanding 12B6 motions, Mr. Dizzley indicated that he was not put on notice. He is incorrect. I'm looking at the notices that were submitted to him, including his notice of this hearing today as to his permanent injunction, and also accompanying that is the motion 12B in lieu of answer as to all of the remaining defendants. It was filed on March 27, 2024. And notice was sent to Terron Dizzley in the Allendale Correctional Institute at 1057 Revolutionary Trail, Fairfax, South Carolina, 29827. So I find that he was sufficiently noticed for the 12B6 motions, and I'm prepared to rule on those. As to the 12B6 motions, as to all defendants, I'm going to grant the motions to dismiss. As to the Miss Elliott, as obviously she is entitled to judicial immunity. And under the Sheriff's Department, I'm going to grant it as to res judicata. I'm not overly concerned about the statute of limitations and not taking that into consideration. As to the remaining defendants, I find that they have prosecutorial immunity. As to Ms. Bailey, Mr. Henry, the Georgetown County Sheriff's Department, Jimbo, Jimmy Richardson, and Scott Hickson, they all have that immunity, and they are entitled to that immunity, and therefore I will grant those motions. As to the permanent injunction, I'm going to deny that permanent injunction. And And, moving forward, Mr. Dizzley, what they are indicating is that any further filings must be filed by either yourself, signed by yourself, or in the alternative, they must be filed by an attorney. Do you understand that?
Sir, the power of attorney form is only for filing things. This is for filing in the clerk of court. It has nothing to do with my mother being a lawyer for me.
And that's that. I said, do you understand that moving forward, that all filings have to be signed by yourself and or by an attorney, not some power of attorney or your mother? Do you understand that?
Well, Your Honor, according to the law, it's legal.
All right, well, I'm just gonna, I can, at this point in time, just preclude you from filing anything if that's what you like.
Sir?
I can preclude you from filing anything in this case if that's what you would like.
You know that would be an administrative decision, right?
No, it's a judicial decision that I can make. Do you want me to do that, or do you want to file
That
on your
falls
own
outside
behalf?
the scope of your judicial function. That is administrative function.
Do you want me to allow you to continue to file things if you sign them or if an attorney signs them? Yes or no?
I just want to be afforded due process under the law, sir.
And I'm trying to
Under
afford you that, but you
14th
have to, if
Amendment.
you want to represent yourself, you have to abide by the rules.
I am, sir, and I'm trying, the 14th Amendment, I'm required equal protection of laws.
All right.
I have not received equal protection of
right.
laws in this hearing.
All right,
No,
so,
due process.
hold on. So put it in the order, he is precluded and barred from filing anything in this case, unless he is willing to abide by the rules, where he has to sign it or have an attorney sign it, that we will not accept any filings on behalf of him, from his mother, all right? If y'all should prepare a short order for me, we'll get it, signed off on, okay?
Your Honor, I
Thank you very much.
want to say
Yeah,
that, did you get my, response to the filings?
Can I shake my brother's hand? No? Bro.
Madam Clerk?
Case number one.
All right. We're just gonna go down the roster now.
Right.
All right, not a problem. Irene Clodfelter versus